Hi, everyone. We see you all filing in. Thank you so much for joining us. We are going to give a few minutes to allow people to get logged into the meeting before we start. We plan on starting about 6:07. And please remember that this session is being recorded and also live streamed on YouTube at this very moment. For all the people that just joined, we are giving everyone till about 6:07 to file in before we get started. So just bear with us another moment or two. Welcome, Jermaine. I see your question. I cannot see you on the screen. We can't see anyone on the screen except Martin and myself. But thank you for joining us. And if you have any questions, you can put it in the question box. Felicia, I also see your comment. We are going to try to hold questions until the end of the presentation. We hope that the presentation will answer most of the questions that you have, but feel free to put them in the chat box or put them in the Q&A, and I promise we will get to every single one of them once Martin gets through the presentation. Okay, it looks like it is 6:07. We're going to go ahead and get started. Thank you all for joining us this evening. We know with kids and work and all of that, sometimes it can be hard to take some time out to listen to a webinar. My name is Inez Bordeaux. I'm the manager of community collaborations at Arch City Defenders. And I'm gonna that's the wrong word. I'm gonna ask my colleague, Martin, to introduce himself and tell you a little bit about how this project came to be. But very briefly, part of almost everything that Arch City Defenders does, all of the work that we do really comes from this place of wanting to re-envision public safety. And when we talk about re-envisioning public safety, we're talking about putting policies into place that actually make the city safer for all of us. We talk a lot about divesting from carceral systems. Carceral systems mean prisons and jails and police. So we want to divest from those things and invest in people and communities. That's how the city thrives. That's how our neighborhoods thrive. And that's how we all thrive. And part of doing expungements means that, you know, by helping people clear their criminal records, it opens up an entire world of possibilities for them that they didn't necessarily have access to before. Having things on your criminal background can keep you from having access to safe, affordable housing, from having access to educational opportunities, having access to certain jobs. And so part of the work that Arch City Defenders is doing, again, under this idea of re-envisioning public safety, is this expungement program. So now I am going to turn it over to my colleague, Martin Hutchins, and he's going to tell you a little bit about how the program came to be and walk us through the process. Martin, it's all you.
Thank you very much, Inez.
Right. One more thing, if you have questions for everyone who may have just came onto the call, if you have any questions, please utilize the question and answer box. Please utilize the chat box. We're going to try to make it through. The session, and then at the end, answer all of the questions. Thank you. Go ahead, Martin. Sorry about that.
No worries. Thank you very much, Inez. As Inez mentioned earlier, my name is Martin Hutchins Jr. I am a staff attorney and the Racial Justice Fellow at Arch City Defenders. And the Expungement project has been initiated for a few different reasons. Firstly, and really to give understanding of why we're doing tonight's session and yesterday's session, we primarily want to help the community just to get a better understanding of what is necessary to pursue expungement in Missouri, and to also just to raise awareness and individual curiosity in the sense of we hope to spark curiosity to people in the community so that more individuals will begin to pursue expungement. It's a legal option that far too few people are pursuing in Missouri. So we want to help increase that number and again, raise people's individual curiosity to see, hey, maybe I qualify for expungement. Maybe this is something I need to pursue. So this is our effort to plant some seeds of curiosity in everyone. So there are actually a few different laws that relate to expungement in Missouri. And we're only going to focus on one specific law, which is law 610.140. So generally, the word expunge just means to destroy, to totally get rid of. In the context of criminal records, that definition varies from state to state. So as it relates to Missouri, expunge means to just have a record sealed. So you actually will come across a few states that have expungement laws that result in a person's criminal record being totally destroyed in Missouri. So again, once a record is granted expungement in Missouri, it's sealed, which means it's made more confidential. So that means the record still exists and is still accessible in certain situations and for certain parties, like prosecutors and judges, if there are later cases in which a person is receiving a sentence for, their sentence can be enhanced by an older offense, even if that offense was expunged. Certain employers have the right to get information about offenses that are expunged. So again, those are just a few examples in which individuals still have a right to access records relating to offenses that were successfully expunged in Missouri. And finally, in order for expungement only has an impact on the courts and the various state entities that are involved in the expungement action, which we are going to go into a lot more detail about. So again, just note, in Missouri, once granted an expungement, your record still exists. So I'm actually going to go back a little. So as I mentioned earlier, statute number 610.140 is the primary law for expungement and will be the focus of our session today. And statute is just another word for law. So the law that we're focusing on today went through some major changes back in 2018 and just opened up the options of who may be eligible for expungement. So once January 2018 came, the number of offenses that are eligible for expungement drastically increased, and the required waiting periods also shortened, which again, we're going to go into a little more detail later. So why now? As I just mentioned, those major changes in 2018. But even beyond January 2018, the expungement law has had a few changes that have been beneficial to, that's been super beneficial to people with certain offenses. So for instance, in January 2018, stealing was listed as an offense that was just flat out ineligible for expungement, meaning if a person had a conviction for stealing, they would never be able to pursue expungement for their stealing offense. However, back in August 2019, the law was changed and now stealing is eligible for expungement. So that's just one instance of another change that has happened to the law beyond those changes in January 2018. Recent reports from the state of Missouri, including the annual judicial report that's released every year, revealed such a low number of people that have actually tried to apply for expungement back in both 2019 and 2018. These numbers are pretty low. In 2018, a little under 1,200 people applied for expungement in the entire state of Missouri. And of that 1,200 number, less than 400 people in the greater St. Louis area pursued expungement. And in 2019, a little under 1,300 people applied for expungement. And so this number is just drastically low to reflect the number of people that are applying for expungement in the entire state of Missouri. There should be more than 1,200 people in the greater St. Louis area alone applying for expungement. So that number should be far greater for the entire state. So again, we want to help raise awareness to raise that number. And most importantly, a criminal record just creates several barriers for people. A criminal record can prevent you from getting financial aid. It can prevent you securing housing. It drastically reduces the housing options for certain individuals with criminal records, and employment. But even more pertinent now, we are 7 months into a global pandemic. And as we are, as a society, bouncing back from this pandemic, there are already indicators of hardships that people are facing with employment and housing instability. So those individuals with criminal records are going to face those hardships even more so because they were already facing hardships from their criminal records before the pandemic. So again, those hardships are going to be far greater beyond COVID-19, which makes expungement even more ripe for discussion now. So throughout the entirety of this session, we are going to primarily focus on the requirements for expungement, meaning what is the criteria that a person must meet in order to be granted expungement. And as the slide shows, there are 5 categories of requirements that we're going to discuss. And after those 5 requirements, we'll have a brief discussion about the results that follow expungement and issues that people encounter in their pursuit of expungement. So again, for our presentation, we're only going to focus on the requirements. We won't go very much into detail about the court procedure of filing the petition and making various arguments. So the first requirement that we are going to cover is determining if the offense itself is eligible. And so here, the focus is only going to be on the actual offense that a person may want to expunge. So again, this category is going to focus only on the offense. This category won't give much individual focus to the person. So we're only going to talk about the law that correlates with whatever violation is on a person's record. So I'm going to break this down to big categories. The expungement law has a section that has several specific laws listed as being ineligible for expungement. So as I mentioned earlier, in 2018, stealing was flat out ineligible for expungement. So that was a statute that was specifically listed by the expungement law as being ineligible. And so for the first section of this requirement, we're going to talk about those specific laws. And so there are about 85 offenses that the expungement law expressly lists as being ineligible for expungement. And here are about 10 of those laws that's mentioned. And again, there are about 85. So here listed, I have arson in the second degree, which first degree arson is also ineligible. Forgery, identity theft, mortgage fraud, perjury, possession of firearm for certain person, robbery in the second degree, etc. So these numbers right here are the statute numbers. And the expungement law has a section, again, with a large paragraph listing about 85 offenses that a person cannot pursue expungement for at this point. Now, as I mentioned earlier with stealing, as time goes on and more changes are made, it's possible that this number would decrease, and hopefully so. This is but one of several changes to hope for. Now, in addition to the specifically listed statutes, there are a few broader categories of offenses that are also ineligible. And for those broad categories, they include Class A felonies, any dangerous felony under this specific law, which generally includes arson, rape, sodomy, kidnapping, special victim assault, crimes against children, et cetera, meaning the remainder of my list. But again, this indicates which offenses a person may have been either arrested for or received a conviction on their record, and that offense itself is not eligible for expungement. So a few more of those categories include any offense that requires registration as a sex offender, felony where death is an element like murder or manslaughter, meaning in going through the court process, if the state would have to prove that another person died, that means that death is an element. Therefore, your offense is not eligible for expungement. Any felony offense of assault, domestic assault, including at the misdemeanor or felony level, and felony kidnapping. Number 6, which the expungement law lists all of the statutes that we talked about earlier, so I won't go over those again. Number 7, any offense eligible for expungement relating to alcohol-related driving offenses, intoxication-related traffic, boating, and aircraft offenses. Number 9, any ordinance violation that are the substantial equivalent of listed non-expungible offenses. So I want to unpack this a little bit. So an ordinance when thinking about ordinance violation, you will generally encounter these when you're dealing with a municipal jurisdiction. So dealing with St. Anne Municipal Court, that would be an ordinance violation. So an ordinance violation that is the substantial equivalent of a non-expungible offense could include, back in 2018, again, when stealing was flat out ineligible, any person receiving a ticket from the St. Anne department, for example, for stealing, although at the municipal level, because that ordinance relates and closely resembles the Missouri state law for stealing, and it was listed as ineligible, that offense for municipal level stealing would also be ineligible. So with ordinance violations, a couple of common ordinance violations that have a Missouri state law that is pretty identical would include trespassing, stealing, larceny, but there are a couple other examples that aren't quite as clear cut, which brings me to my first mention, which I'm going to mention this a few times throughout this presentation. This process that we're going through is one that people really need legal counsel for. Expungement really requires an attorney. It should require an attorney. There are options to represent yourself in expungement, and the court even provides a pro se form. However, this law is very difficult, and not many attorneys themselves can successfully achieve expungement at this point. It's just a very difficult law. So with that being said, it's absolutely best to pursue this with an attorney. And so with the process we're going through, again, this is really meant to plant the seed of curiosity to get individuals to become more aware of it and to start considering their own eligibility to make the decision to pursue an attorney, whether that's a paid private attorney or pursuing legal services from an organization like our City Defenders or Legal Services of Eastern Missouri. And again, I totally recognize the high expense, the time restraint, and looking for legal services, especially where a person needs to find one for no fee. So I don't say that very likely, but again, this is absolutely a process that a person needs an attorney for. So back to my presentation, the ordinance violations and determining which ordinance violation has a substantially equivalent Missouri state law, that would be something an attorney will be very helpful in doing. And the last two broad categories include any violation of law regulating operation of motor vehicles by a person who has or is required to have a CDL license, which is a commercial driver's license. And finally, any weapons offense under the category that includes carrying concealed before that was actually legal. So those are the broader categories of offenses that are just ineligible. So our next set of requirements focuses on timing. The expungement law has a couple of timing requirements that must be met. So the first, as my slide indicates, is a waiting period. So this refers to once a person is sentenced and they have completed their sentence or disposition. The law uses the word disposition, which just means sentencing. Once that sentence is completed, meaning if a person was sentenced for a misdemeanor to 6 months of probation and required to do 50 hours of community service, that disposition is not completed until that probation period has been successfully completed and discharged, and that community service has been completed fully. And so this waiting period starts to calculate from the point of the disposition being completed. And so this waiting period says there must be, for felonies, a 7-year period beyond the point of a person completing their disposition, which is again the sentence. And for misdemeanors, it has to be a 3-year period in which the person has completed all the obligations the court gave for that person's sentence. And next, the person must be crime-free during that waiting period. So again, for a person pursuing expungement for a felony offense, they have to show that they have been crime-free, meaning no convictions, no entering any pleas of guilt during that 7-year period for felonies. For misdemeanors, that period is going to be 3 years. Now, calculating that time is a bit unique. So when making your consideration of, do I want to pursue expungement, it's important to note that when calculating your period, the court looks at the date in which the petition for expungement was submitted and counts backwards. So at this point, we are not filing a petition. We're only thinking to ourselves, do I qualify? So a good starting point would be to just take today's date or whatever day you actually begin thinking about that process and count backwards. So if I have a felony conviction that I want to start pursuing expungement for, that means my period is 7 years. So it's October 21st, 2020. So I'm going to count back 7 years, all the way back to October 21st, 2013. And so from today, all the way back to October 21st, 2020, I must have already been completed with all the obligations imposed with my sentence. Again, whatever fees or community service requirements. All of those obligations must have been fulfilled before that period began. And also for that 7-year period, again, from October 21st, 2013, all the way to today, I must not have received any more convictions or entered any pleas of guilt during that time. So again, those are the timing requirements for expungement. So one thing to note here, it would be important to know dates that relate to your case. When were you complete with your disposition? When were you discharged from probation? When did you complete your community service and give the court a verification of that community service? Which is not always super easy for individuals to gather that information and to correctly recall those dates, which is another reason to use an attorney during this process, because we're partnering with an attorney. Yourself and your attorney can work to gather that information to make sure that you are getting the best and most accurate information about your own record. And as we go on in our presentation, or actually towards the end, I'm going to show a few resources to help individuals begin that process of gathering information about themselves, about their criminal records, identifying the law that they were convicted under to identify if it is ineligible, and a way to actually pull the expungement law itself. So the next category of requirements, are you currently free of charges or unsatisfied obligations? So the first requirement under this category asks, have you satisfied all obligations related to the offense itself? So this closely correlates the waiting period that we just described. So for the offense itself that the individual is seeking expungement for, all of the obligations that the court required a part of their sentencing must be complete. There can be no unfinished disposition obligations. So the community service, again, must be fully completed. That period of probation must be completed. And finally, do you have any pending charges? So if a person has any pending charges when they file their petition for expungement, they will be deemed to be ineligible. And so again, using an attorney would be a great way to ensure you don't have anything pending. And this is an issue that really hits home with St. Louis, especially the St. Louis County area. We have so many municipalities in that area, and it's very common for people to not realize that they have charges pending. We have several areas in St. Louis County and several streets in which if you drive for 10 to 15 minutes, you're going to hit at least 3 different jurisdictions. And so again, it's very common for people to lose track of traffic tickets or to still have matters pending from decades ago. So in partnering with an attorney, that's a great way to try to catch some of those things, to make sure that you aren't trying to file your petition for expungement when there's still a traffic ticket from 2005 out there. So the next category of requirements, a great way to summarize this is will the court's discretion determine that overall you deserve to be granted expungement? Will the court's judgment say that the person pursuing expungement deserves to be granted expungement? And so the requirements that we just covered before this are objective, meaning they're more clear-cut and don't give much opportunity for individual interpretation. Is more clear-cut than this category. So for instance, in talking about the offenses that are just flat out ineligible, either your offense is either eligible or ineligible, especially for those that are listed. So that's an example of one of those requirements that doesn't really involve the court's discretion. And by saying the courts, I'm referring to the judge. So those are requirements that don't really give much room for the judge's own discretion to make a decision. But the section or the category of requirements that we're about to cover now are largely based on the judge's own discretion. So the first requirement here asks, does your habits and conduct demonstrate you're not a threat to the public safety of the state? And is expungement consistent with the public welfare and the interests of justice warrant the expungement? So this is the judge considering the person's record and overall after the petition has been filed and all of the information has been presented about that person. Does this person's total package show a person that deserves to be expungement? Does the total package of this person, including their record, their involvement in the community, their family life, does considering the total package of this person show a person that deserves to have their record sealed? And so information, as I just mentioned, about employment, like a person that's been on their job for a while, or a person that has been achieving advancement in their role, can be information that can weigh in favor of that person being granted expungement. Information showing commitment to one's family, it can be a factor in favor of expungement. Community involvement, is this a person that is really active with the youth in their environment? Is this a person that's really active with their church? Those are all factors to add to the total package of the person asking to be granted expungement. And so this category of requirements isn't quite as easy to make a judgment, an individual judgment and evaluation when making that consideration of whether to pursue expungement or not. And again, I'll mention once more, if you have any questions, please ask in the question section or in the chat box, and we'll get to those questions at the end of the presentation. So the next category of requirements pertain to lifetime limits. So these are limits that the expungement law has imposed that, as the slide indicates, limit who can actually pursue expungement. And so this category really relates to those that may have already received an expungement, or maybe a person that may be attempting to expunge multiple offenses, which is very common. So this section presents the greatest barrier to full expungement. And by full expungement, for the purpose of this presentation, full expungement allows a person to say that they have no criminal record. However, people have multiple offenses that can be expunged. And so deciding whether to seek or which offense on my record to expunge can be a difficult decision. So those limits include, for misdemeanors, a person can only have 2 misdemeanor offenses expunged where those misdemeanors have an authorized term of imprisonment. And so generally, all misdemeanors have an authorized term of imprisonment. The misdemeanors that don't have an authorized term of imprisonment largely include Class E misdemeanors. Otherwise, most misdemeanors all have an authorized term of probation. I'm sorry, please pardon my dog. She's very excited right now. The next limit pertains to felony offenses. There can only be one felony expungement granted, meaning a person can only have one felony offense expunged. There is no limit to how many infractions may be expunged, and a person's record receives infractions for violations like minor traffic violations. And so again, as I mentioned earlier, making the decision of which offense to expunge can be very hard. The timing of pursuing expungement can also be a difficult decision. As I mentioned earlier, the law is constantly changing. I'll repeat, in 2018, stealing was flat out ineligible. That's no longer the case. And I am going to project that a few more of those offenses will become eligible. So that leads to the problem of thinking, should I pursue expungement now because I have something on my record that is eligible, or waiting until later to see if maybe something that's on my record now that is ineligible will later become eligible. So that's just a part of legal strategy that, here comes my plug again, an attorney will be very helpful for. Making the effort to try to gather legal resources is going to be especially crucial for this process. So there is one exception to these lifetime limits. And this one exception has two ways of achieving it. So it would probably be more appropriate for me to say two exceptions here. So one exception is going to include if a person has multiple offenses that were charged on the same charging document, meaning the indictment or the information. So if a person has 3 felonies on their record, and all 3 of those felonies was charged on one indictment, then that person can pursue to have all 3 of those felonies expunged. So again, the first exception says there were multiple offenses charged together on the same charging document, meaning an indictment or information. And that would allow you to bypass these limits. So if it's 5 misdemeanors and they all have an authorized term of probation and 3 felonies all on one indictment, then theoretically that person can pursue expunging all of those offenses and have a good chance considering all the other requirements are met. The other exception is one that is going to be especially important to have an attorney for, because this is going to require a little argument. And this exception says where there were multiple offenses a part of the same course of criminal conduct, then all of those offenses can be expunged. And so there's a case a couple of years ago for a young lady pursuing expungement. And unfortunately, she wasn't granted the full expungement that she pursued, but she had about 2 felonies expunged, 2 of about 5 or 6 that she was pursuing. And this case involves a person that was convicted of multiple charges of passing bad checks. And so she was pursuing to have, or attempting to have, all 5 of her felonies expunged. And so she didn't quite get her way because the court determined the time period over all of her offenses was just too long to say it was the same course of criminal conduct. The law about passing bad checks has a part in there about time period, and they use that time period to say because she exceeded that period, it's not the same course of criminal conduct. But an example to give you with bad checks, let's say a person has a felony for passing a bad check in Moline on Tuesday, and then the following Wednesday, they are convicted for passing bad checks in Pine Lawn, and then they're convicted for passing bad checks in Dellwood the following day. It's more likely that all 3 of those felonies will be convicted because they're closer in time and they're all the same offenses, passing bad checks. And so that's a closer example of where that exception of the same course of criminal conduct might find in favor of that person having all three of those felonies expunged, and therefore exceeding the one felony limit placed by the law. But again, this is something that's going to be especially crucial for an attorney to assist with. So now we're beyond the requirements, and now we're going to dive into the results of expungement. What's the impact of expungement for people that are successfully granted expungement by the court? So the first I have listed on my slide is the effect of expungement is to restore the person granted expungement to the status he or she occupied prior to such arrest, plea, trial, or conviction, as if it never happened. So the attempt to return that person to the status that they were at before the offense happened, that they were just granted expungement. The next result is no person who has received an order of expungement, meaning no person that has successfully been granted expungement, shall be held guilty of perjury or otherwise for giving a false statement or for failure to state or acknowledge such arrest, plea, trial, or conviction. So that means the person has the right to answer no in certain situations when asked about a criminal record. And so there are, unfortunately, a few exceptions to that, which we are going to discuss in the next slide. So more results of expungement. And these results are more so going to focus on what are some of the obligations that the person who has been granted expungement must still follow as it relates to their record that was expunged. So first, the person must still disclose the expunged offense to any court when asked upon being charged with any other offense, violation, or infraction. So in short, if I'm granted expungement today and next year I am arrested for stealing and I go to trial and I'm found guilty and I'm about to receive my sentence, the court will consider my expunged offense, and I have a duty to disclose that offense if for some reason the court is unaware of that expunged offense. So again, that's one example of how the expunged offense can still have an impact on a person. Next, the expunged offense may be considered a prior offense in determining a sentence to be imposed for later offenses, which I just briefly mentioned. So the second bullet says that the expunged offense can have an impact on your sentencing, and the first really just relates to the duty of the person to make sure that the court is aware of that expunged offense. And finally for this section, or this slide rather, the person must disclose when necessary to complete an application for certain licenses, permits, and for certain employers. So a few examples of these licenses will include a nursing license. That's an application that's going to require full disclosure of all offenses, including expunged offenses. And certain employers, they have a right to know about all offenses. Generally any employer that deals with children or any group of vulnerable people, like maybe a nursing home, a daycare center, a mental health institution. Those are examples of employers that have a right to receive information about expunged offenses. A few other broader categories that will require a person to disclose information about that expunged offense include any license or employment opportunity involving gaming operations. So like the casino, any emergency service provider, any saving institutions or credit unions. These are all examples in which a person must disclose their offense, even when it has been successfully expunged. So some issues that are generally included in the entire realm of dealing with the criminal legal system of our country really involves the hardship that people have in gathering information, recalling information, and fully and completely reporting information. So again, referring to an example I mentioned earlier, it's very common for people to have several tickets that they either took care of long ago and just forgot about, or it's common for people to still have several open cases that they are just not actively aware of, which isn't too far-fetched, especially considering, again, there are so many areas in St. Louis in which you can drive for under 20 minutes, but still pass through several jurisdictions. And so just, again, gaining access to that information to fully and completely report that information is an issue. Some of that information that is required when preparing a petition for expungement, and by petition, I mean the application that's going to be submitted to the court for the person seeking expungement. That application is going to require information about each offense that the person wants to seek expungement for, the approximate date charged for each offense, the name of the county or municipality for each offense, which, again, one of my examples is so common for a person to think that I got a ticket in St. Anne, but really that ticket was in Breckenridge Hills. They're so close to each other. More information that's required, the case number and name of the court for each offense. And finally, the petition must list certain parties as defendants. The court's order of expungement will not have any effect on that entity that should be listed but was not listed. So just to unpack that a little, for example, if I have a conviction in St. Louis City and I'm pursuing expungement, there are 4 people who I need to include on my petition, which means that these are the 4 people that I am starting court action against. So they are the other 4 people that's going to be on the other side of the V, meaning it's going to be, since my name is Martin Hutchins, it's going to be Hutchins versus those 4 people for my expungement. And so for St. Louis City, those 4 parties generally include the Circuit Attorney's Office, the St. Louis Metropolitan Police Department, the Criminal Records Repository, and the Missouri State Highway Patrol. So those final 2, the Criminal Records Repository, which is the state entity that is responsible for housing and maintaining criminal records, that's statewide. So that's going to, that party is going to be listed for expungement no matter where the person is filing. And also the Missouri State Highway Patrol, again, that's statewide. So that party is going to be listed no matter where the person is seeking expungement. So the other 2 will change. So in St. Louis City, it's going to be Kim Gardner's office, the circuit attorney. However, if I'm seeking expungement for a St. Louis County offense, I'm not going to include Kim Gardner. I'm going to include Wesley Bell's office because that's the St. Louis County prosecutor. And also, I'm not going to include the city police. I'm going to include St. Louis County Police Department. In Kansas City, it's going to be the Kansas City prosecutor. It's going to be the Kansas City Police Department. And that's important because once the judge determines that you are granted expungement, the court issues an order which says, I'm granting this person expungement. So you four parties, whatever records you have, you need to make those records confidential. So if that person is not listed, then that order won't apply to them. And they can therefore still have not only maintaining the record as they have always, people that are going through your background for jobs or housing, they will still have public access to that record from that state entity. And so again, using an attorney would be a great way to make sure all the necessary people are listed on that application for expungement. Another issue, which I briefly touched on, is it may be a good idea to wait to pursue expungement, especially if you're a person that has an offense on your record that is, as of right now, considered ineligible, because this law is undergoing changes, as all laws are. But as mentioned earlier, a few of those offenses that were once ineligible are now eligible. And so that list will continue to dwindle down and more offenses will become eligible. So again, there's the issue of waiting to see what our elected officials would do with the expungement law, or just going forward and pursuing expungement now, which is going to be a strategic decision that your attorney can help you out with. And for the final slide of issues, the first point I think is properly categorized as an issue because it relates to money. And so I've already said maybe about 8 times that this process really needs an attorney. And so other than those that are able to secure a free attorney, it's likely that people will have to pay some sort of fee for their attorney in its expungement process. So in addition to paying for your attorney, the state also requires certain fees for this process. So there's a $250 surcharge fee for expungement, in addition to the basic civil filing fees. And those civil filing fees are going to vary from jurisdiction to jurisdiction, meaning the filing fee in St. Louis City is going to be different from the filing fee in St. Louis County, which is going to be different from the filing fee in Boone County, in Kansas City, etc. Now, this bullet point right here includes a link for an application that's referred to as an application to proceed as a poor person. And so this asks the court to consider a person's financial resources to determine that they are indigent, which an indigent person just means a person of low financial ability. And if the court does grant that order to proceed as a poor person, a few of those fees will be waived, like the surcharge and the filing fee. Unfortunately, that does not waive the fee that's going to be paid for the attorney. And that also is not going to waive whatever direct fees people pay or whatever money people are missing out on because they're spending time and hunting down records instead of working the overtime that they may want to work. Or it's not going to waive whatever additional fees that parents may need to pay for childcare because a person is taking time to work on their expungement. So yes, this order to proceed as a poor person is helpful, but there are so many expenses related to expungement in all legal matters. So again, this is categorized as an issue because there shouldn't be a process to waive this fee, because there shouldn't be a fee. And finally, which this bullet point is going to be another crucial factor as to why seeking out an attorney is so important. If the court determines that a person is not eligible for expungement, or that the submitted petition for expungement is denied, that person cannot pursue expungement for that offense for another year. So there may be someone out there that has the thought, well, that's only a year. But that year means that this is another year of a person dealing with the barriers caused by that criminal offense. That's another year of not making as much money as they possibly should be making with their employer because they've had to report this offense. Or that's another year that a person needs to remain in housing that they aren't happy for, but they just feel stuck because their housing options are limited. And another reason why this year is just really unacceptable, because this is, again, just another year of dealing with all of those impacts beyond the time period that individuals have already been dealing with the impact of their criminal record. So to risk being delayed a year for submitting in petition for expungement that either really was just flat out ineligible because it's an offense that is listed as ineligible, or is missing information because a person had difficulty in finding all of the information about their previous records and their previous sentences, is something that I would really press everyone to put effort into gathering that information on the back end before going to the court and filing that application, because there's so much vetting that can be done and individual research that we as an individual person can do and our legal counsel can do to ensure we're filing a petition that's as likely as possible to be granted expungement. So finally, I'm going to go through just a few resources that individuals can use just to try to help with their own individual consideration as they are beginning to think about expungement as it applies to them, or just information that one should just have generally. So the first is going to be CaseNet. So searching CaseNet is going to be a great way to try to get information about some of your previous offenses, including convictions and even matters that are pending. Now, specific to the greater St. Louis area, more and more of our municipalities are coming over to CaseNet and having all records and court dates available there. Not all of them are in full compliance as they should be, meaning our court has ordered all of our municipalities to actively use CaseNet. So at one point, they all should be in full compliance, but we're not at that point yet. So I'm actually going to exit out of this full screen just to quickly breeze through some of these resources. So again, this is CaseNet, and click on this little house icon and going to litigant name search is a great option to try to search your own record. And I point this out just to make just to bring attention to this resource, but I don't mean to imply that it's a super friendly site or one that's going to produce all the information necessary. But it has the possibility of giving a few tidbits of information, which actually relates to another issue. Although this is a state site, as a couple of the other sites we're going to visit, some of this information is just very inconsistent, which can have a negative impact on a person pursuing expungement. So the next site I'm showing is municourt.net, and this only relates to municipal courts in the greater St. Louis area. So again, this would be a great resource to either get information about older records or even pending matters. So this would absolutely help with that expungement requirement that asks, do you have any pending charges? Even if a person is totally sure that they don't have anything pending, I will still press to just take effort to verify that there isn't anything pending. And municourt.net is going to be a great way to verify that as it relates to municipal courts. So the next is only specific to St. Louis County, and this is their traffic/criminal case search. And so again, like I just mentioned with municourt.net, this can help you identify if you have any pending charges in St. Louis County, and even give you information about some older charges that may have been taken care of. And I'm using the word older very, very loosely here. And this is totally speculative. I wouldn't expect to see a record on this site from the 1970s. And very similar to this site is the option for St. Peters, Missouri. So again, this is only for St. Peters, Missouri, and this can also help reveal if you have any pending charges in St. Peters, or information about some older charges that you may have already entered a plea in or had a trial for. So the next site I'm going to show you is the Missouri Reviser of Statute sites. And this is the site that you can go to pull various state laws. So yes, I'm to a site that pulls up laws, which are not the easiest things to read. Lawyers often spend hours trying to fight over what laws mean. So I don't show this resource very lightly. However, I'm just going to put their resource out here. So you can use this section if you are a person that for some reason actually knows the statute number. You can just type the number and it'll pull your law, or you can try to identify that law by a few key terms. And this is going to be especially helpful when trying to identify if your offense is something that is just flat out ineligible. And so this tab I'm about to click on is just my pulling up the exact expungement law, which is 610.140. And again, I don't show this to indicate that this is going to be a very easy document to read, because it's not. But this is the area that lists all those specific statutes that are just flat out ineligible. So clicking here would show you the exact law that it's identifying. So this relates to perjury. So this will be helpful is in the event you go to CaseNet, you find record of your conviction. CaseNet will actually show you the statute number that relates to your offense. And if you see that offense number listed in the expungement statute, which I have lost, there we go, then you can make a determination that my offense is or is not listed in that section. But again, and this is going to be my last plug for this, but doing this evaluation is why getting an attorney is going to be especially helpful. So I'm going to take these last few moments to see what questions we have and to answer as many as we possibly can. Inez, if you...
Yeah, I can do the questions.
Oh, okay. I was going to say, if you see any hot skill, please let me know. We can go this out as well.
Cool. Are you ready now?
Yes.
All right. I'm going to start in the chat box. Felicia asked, I'm just going to read it because it's a little long. My last felony case was in 1998. I haven't had any trouble since then. She's been working in the nursing field because of her good cause waiver. Her question is, how accurate is using a police report to write down your charges? Can you put down all cases to have expunged? She's been checking on this because now she's in school and she knows once she gets closer in the nursing program, she'll have to go through a background check. So again, the question is, how accurate is using a police report to write down your charges?
That's a very good question, Felicia. And this really correlates with one of the issues that I mentioned earlier, just the problem of finding complete information and getting consistent information, especially relating to police reports. It's likely that the information included on a police report, the violations alleged in the police report, are very different from the actual offenses that a person either entered a guilty plea for or were found guilty for at trial, especially in a situation where there is a plea deal. It's likely that a different offense was offered by the prosecution. So the short answer is the police report, it can be helpful, but not within itself. It can be one record among many other records that you and your attorney can find to try to pull your total record. So yes, the police report itself can be helpful, but not solely within itself. But again, that's something the attorney would absolutely be able to help you out with. So the next question I see is, once expunged, will a record show up when you do fingerprints? There's a possibility that such a record can still be found. So an order of expungement comes once the judge determines that a person is eligible for expungement and they win their case. However, that order comes from a Missouri judge. So if you're a person that moves out of state, that order won't have an impact on that state. So if that record is found somehow, it's possible that it will always be out there. So an example of how a record may still be found after expungement, let's say in 2010, I applied for a job. It went through a background check, and that background check found my stealing conviction, and I don't get the job. Now, fast forward to 2017, fast forward to 2019, when I am successfully granted expungement for my stealing offense, and I then go on to do another background check. There have been instances in which a background check finds results based on older and previously performed background checks, because those background checks are often performed by private parties. And so, as I mentioned earlier, the order of expungement won't have an impact to private individuals. It only controls the record as it exists with those state parties that we list, meaning the prosecutor, the police department, the highway patrol, and the state criminal repository. So the short answer is it's possible.
Martin, did you just read that question out of the Q&A or out of the chat?
The Q&A, thank you.
Okay, I'll read the questions for you. That way you can just focus on answering them. Angela asked, that, paraphrasing here, she was arrested 22 years ago, never saw a judge, was never charged with anything, only arrested. So now when she does background checks for certain jobs, the arrests pop up, and she wants to know, can it be expunged? Can that arrest be expunged?
Excellent question. So just very quickly, there are a few different statutes out there for expungement. So our focus right now is on the statute 610.140. There's another law specific to expungement of arrest. It has a much higher threshold because it requires a showing that the officer lacked probable cause, which is a very high standard. But with that being said, the law that we're focusing on here can also be used for the expungement of arrest. And so in going through those requirements to determine if you're eligible, it still is going to boil down to the offense that the person was arrested for. So for instance, if I have an arrest relating to murder, even if I wasn't convicted, that's an offense that's flat out ineligible. So even though I wasn't convicted, that arrest relates to an ineligible offense, therefore it's not eligible for expungement, which is absolutely a point that I am hoping our elected officials change in the law. But the short answer to your question, yes, an arrest can be expunged. It just depends on the offense that it relates to.
Okay, good. ML wants to know, is there an easier way to cross-reference your type of charge to what statute it falls under?
Good question, and an even better point of aspiration for our elected officials. But as of right now, and to my knowledge, there is not an easier way. The process I demonstrated isn't even the easiest, or isn't even that easy for attorneys. So it's even harder to expect non-attorneys to use that process. But as of right now, to my knowledge, there is no easier way. And that way is going to become even more difficult for those individuals seeking to expunge an ordinance violation, because it's going to involve finding the ordinance number, looking to see which Missouri state law it does or does not resemble, and going from that point. So it's a very difficult step in this process. But again, the short answer is no, not that I can think of.
Okay, really quick to everyone, whether you put your question in the Q&A box or the chat, I promise we're going to get to them all. I just started with the chat box. Okay, Matthew wants to know, where can we get information on how and when to proceed under 610.122?
So the statute that this question just mentioned is one I just briefly spoke on when answering the question about arrest. Because the focus of our presentation is 610.140, I'm going to withhold on answering that question and defer you to seek legal counsel. It definitely is a statute that may be appropriate to pursue expungement for, but again, it's not the basis of our discussion, and just to avoid giving not giving the best information for that statute, I'm going to withhold on answering that. But I will say that statute just has a much higher burden to prove, because it relates to or requires showing that the officer did not have probable cause, which is difficult for so many issues considering the country we're in and the state we're in. So to say that probable cause didn't exist is going to entail arguing that the officer was either untruthful or didn't put something in the police report or just didn't have the basis for the arrest that you are seeking expungement. It's a much higher threshold.
Okay. Next question is, if you get your conviction expunged, will you be able to purchase a weapon?
Excellent question. The right to carry is one of the consequences, or losing such right is a consequence that can follow a person having certain convictions on their record. There is guidance out there that shows that this is a right that can be restored once a person undergoes expungement. There may be other steps that may need to be taken, but the short answer to your question is it's a possibility. The right, your rights relating to the right to carry is a right that can be restored after expungement, but more will be required.
Okay. We have a question that says, can an arrest be taken off your record? I think you addressed that a little bit already, that it's a really high threshold that you would have to prove that the officer didn't have probable cause, right?
So that's more so about expungement under the other statute, 610.122. But to your point, we briefly mentioned this, so I'll quickly reiterate. The law that we're focusing on in today's presentation, 610.140, can be used to expunge a record relating to only an arrest. And I'm sorry, in my reiterating that, I wanted to again point out expungement in Missouri means the record is going to be sealed, which means it's going to be made more confidential. And so I'm pointing that out because the question said will be taken off. And there are certain areas in our country that an expungement totally destroys the record. Unfortunately, that's not our state.
Okay, next question. Are expungements expensive? How do you start the process?
Yes, I'm going to say yes. So defining something as expensive is going to be a matter of opinion, but I'm going to say yes. It's expensive in the actual money that it costs. It's expensive in the amount of money it's going to prevent a person from getting, meaning that person that's going through all of the steps to gather their information, to find their records, to find an attorney to represent them, to meet with that attorney. That's time that a person is not working overtime. That's more time that they have to pay for childcare. That's more money to pay for travel expenses, etc. So the direct expenses, yes, it's expensive. All the other correlating costs, yes, it's expensive. It's expensive, period. How do you get started? I am going to say the way to start is trying your best to get an attorney and doing your best to start gathering information so that you can get a full picture of your record as it will be evaluated in the expungement process.
Sorry, sometimes this mute button really kicks my butt. It says I have a 21st degree robbery that's over 20 years old. Can I get that dismissed? I don't know if the 21st is a typo. I don't know, Martin.
Okay, so I'm going to answer it as if it was saying second degree. So as of now, robbery is one of the offenses that is ineligible. So as of right now, is not eligible for expungement. But one thing I want to make clear, that does not mean that the person with a robbery conviction can never receive expungement. That means that they cannot have the record of the robbery conviction expunged. So if I have a robbery conviction, but I also have a trespass conviction, I can still pursue expungement for my trespass conviction, but just not my robbery conviction, because again, robbery is, as of right now, flat out ineligible.
Okay. Is the city ordinance littering expungible? And they also want to know if they can have a copy of this presentation.
Well, I'm going to answer the second question first. We are, and by we I mean our city defenders, will have this material posted. The video will be posted, and so you can absolutely come back and review this video several times. I'll say review as many times as you like. I'm sorry, Inez, would you remind me of the first question again? Oh, littering.
Yes, littering. Also, before you jump in on that, I want to remind everyone that this presentation is being recorded and live streamed on YouTube. You can go to the Deaconess Foundation YouTube page and you can find this video there also. Go ahead, Martin, I'm sorry.
Okay. So in short, and I'm gonna only answer this question as it directly relates to only the offense. So again, remember there are so many other requirements that a person needs to meet to be eligible or to be granted expungement. But as far as the offense itself, littering, yes, is an offense that may be expunged.
Okay. We did this.
So yeah, let's make this our. I think we're at the end of our time, so this may have to be our last question. But I'm going to follow up with some information that you all can reach out to our city to get more information.
Do we have about 6 more questions? Do you think we can run through them really quick?
Oh yes, I'm sorry. I thought we had a hard.
No,
we can take them all.
There is a question about, is it worth getting an arrest expunged? Talked a little bit about it, how it goes under a different statute and the process is a lot harder. Let's assume that the person has the time, energy, and resources to pursue it. Do you feel it's worth it?
Okay, so before I actually get to the meat of the question, I want to make sure I did justice in making this clear. Earlier, we mentioned another law, 610.122, which is specific to expungement of arrest. So that means that law cannot be used to expunge a conviction. However, the law that we focus on during this presentation, 610.140, can be used to expunge convictions and arrests. Another difference to point out, the other law, if granted expungement with that higher threshold, it has a bigger impact than just sealing the record. So that's more closely to the record being destroyed, although it's not totally destroyed, but it's far less accessible than just being sealed, as in the expungement with 610.140. So again, with 610.140, which is the law that we focused on, that can be used to expunge arrests. Now, is it worth it? Much like the question earlier about if it's expensive, and I don't say this in the effort to try to be a smart aleck, but that's really an opinionated question. If a person with an arrest related to a drug charge, that might have a different value for seeking expungement for their arrest if they are trying to pursue a job in the medical marijuana industry or any other industry that may have a problem with such an incident. So it's really just a case-by-case basis, which is very similar to the person that has multiple offenses on their record trying to make the decision of which offense to actually expunge. So it really just depends on the goal of that person, which is, I am so sorry I was dishonest with you all. I said I wasn't going to plug this anymore, but here it comes. This is another reason why an attorney is going to be especially helpful here to help think about that strategy of which offense to seek expungement for, to try to have the biggest impact to achieve whatever goal a person is trying to achieve, whether that's, again, housing, pursuing a certain job, pursuing certain licenses, like a barber's license or a license in the gaming industry. So I'm sorry, that's not something I can answer very shortly. It just depends.
Okay, thank you. Let's see. I have an unclassified misdemeanor. Is that authorized imprisonment for eating on the Metrolink?
Okay. Metrolink Tickets. So that specific example, and I'm going to mention that, or rather put out there, I'm going to assume that we're talking about a ticket for not paying to ride the Metrolink, which is the train we have in St. Louis, in case there's someone on here not from St. Louis or familiar with St. Louis. So that violation does not have an authorized term of imprisonment. So 25 of those violations can be expunged because there is no limit there. You're muted, Inez.
Crap. Sorry, the dog is barking, the kids are yelling in the background. I keep muting myself and forgetting to unmute. If arrests are expunged, can they still be seen when applying for a teaching job, meaning through FBI background checks? I feel like I know the answer to this one since I had to go through this myself when reapplying for my nursing license. They do an FBI background check. So I literally have to disclose anything that could possibly show up because they can literally see everything.
Yes, so thank you for sharing that, Inez. So just a little more information about that. So this really indicates a couple of issues that I mentioned earlier, in the sense of, if there's a previous background check, it's a possibility that even after a record is expunged, that record can still be found from that previous background check or any other way that the information got out to the public from a private person. So again, the order of expungement only has an impact on state entities, meaning the prosecutor and the police. But those are only state entities. So the FBI is a federal department. And so our expungement law says that once a judge orders expungement, that a request must be made to the FBI to close their record. A request. The state cannot order the federal the FBI to seal or make confidential a record. They can ask, but there have been a few accounts of people reporting getting pushback or just not getting the FBI to cooperate with that. So, but even outside of that, a teaching job, and really any position that deals with children, is going to also fit into the exception of parties and people that have a right to get information about an expunged record. So yeah, so specific to your question, there are unfortunately a few ways in which that record would still be identified for the teaching position. And that is also a scenario in which the person granted expungement is going to have an affirmative duty to disclose their record.
Okay, Just really quick, someone asked if maybe I missed their question. It was the question about once you have your record expunged, can you purchase a weapon?
Okay, so I think we briefly talked about it. So that there are being granted an expungement will position a person to have their right to carry restored. There are going to be a few more steps required, but the short answer is yes. There are the person has a right to have their rights to carry restored, but just getting the expungement is not going to be the end all be all. There will be a few more steps generally. So generally, the rights to carry can be restored with a few more steps.
Okay, thank you. This person wants to know, why is the city of Florissant not on muni.net?
That's a good question. I'm sorry, I cannot answer that question. It's a question we had of many municipalities. Well, which just really goes to another issue that I mentioned earlier, in just how often and likely in getting inconsistent records for an individual person. For these several municipalities that we have in St. Louis County, they have very inconsistent practices. For example, who is and who is not on unicourt.net, who is and who is not actively using CaseNet as they have been ordered to long ago.
It's not surprising. Florissant never does what they're supposed to do. So yeah, not at all. Is it preferable to work with an attorney who practices before the county court where the offense was heard, i.e. Franklin or Jefferson County, should the attorney specialize in criminal law?
Okay, so this is Inez, please correct me if I'm wrong. This is a two-part question. With the first part, should they be in the jurisdiction that the expungement is necessary? And two, should they focus on criminal law?
Yes, they're asking, wherever the offense occurred, should you hire an attorney from that same area? And should that attorney specialize in criminal law?
Okay. I'm going to put in great effort to avoid dancing around this question, but it really depends. So the first question, should they only work in their area? I'll say no, it's not a requirement. Could it be helpful? Sure, it absolutely could be helpful. So that's something that myself or any other person that's out shopping around for attorneys should consider. So I can't give a flat out answer to that. I will say there could be it could be helpful, but it's not necessary. So I wouldn't put too much weight on that at all. But I won't give the impression that there couldn't be any benefits. And the second one, should they focus on criminal law? So expungement is actually a civil process that's dealing with criminal matters, but it is a civil process. So I say it to say it's not necessary. But again, could it be helpful? It could be helpful, but it's not absolutely required. So again, I wouldn't put too much weight on that. But in your considering attorneys, please, whenever you go out to hiring an attorney, ask as many questions as you may have. What's your experience in civil law? What's your experience with criminal law? Just so you can get as much information to be comfortable with the decision you're making. Hiring an attorney is a very important one. So just like you're going to go through this extensive vetting process for your own expungement eligibility, put the attorney through some vetting. if it's a private attorney or an attorney that you aren't paying any money for, vet them the same.
Okay, this person wants you to know that this is an awesome presentation and thank you for doing it.
Thank you for being here. I appreciate that.
Their question is, they have two questions. We can do one at a time. What does an authorized term of imprisonment mean? And then the second question is, what happens if you're applying to get what happens if you're applying to get records in both St. Louis City and St. Louis County expunged? Do you have to file two different petitions? They're also not sure if that's the right word, but I'm sure you'll let us know.
Well, let me give them their roses right now. That was the correct word. So enjoy your roses there. And I appreciate that sticking, because I really intended to just say application. It's always a point to try to avoid too much legal jargon. I digress a bit. So one, what does an authorized term of imprisonment mean? That means that if a person is convicted of a law that has an authorized term of imprisonment, that means that the court, after finding them guilty, has the ability to send them to be incarcerated. So just to add a little more background to that, if a person is found guilty and immediately sentenced to probation, that the law that they were convicted under may still very likely have an authorized term of imprisonment. The judge just did not sentence them to be incarcerated. So that's going to be, that's just going to really require reviewing the law that the offense relates to. And was the second question, what is a petition, or was it another one?
It was just those two. The one about the authorized term of imprisonment.
Oh no, St. Louis City, St. Louis County. So it was really a three-part question, Inez.
Okay.
Yes, that would require submitting a petition in those two jurisdictions. That's the short answer. So the petition for expungement is going to correlate with the jurisdiction that the offense occurred and was processed by. So again, remember, the prosecutor and the police department is going to change based on where the offense occurred and was processed.
Sorry if you guys heard that. This is a follow-up from one of the earlier questions about is it worth getting an arrest expunged? They said the arrest were for domestic assaults. So I guess your answer may be the same. Like if it's preventing them from pursuing educational goals or job goals and things like that, and if they have the time, energy, and resources to do it, then it might be worth it.
Yeah, so this is really going to be a case-by-case determination. Different offenses have different impacts on people and the goals that they may have. And I apologize for the dancing around this question that I am engaging in, but that's really a individual determination that getting an attorney would be very helpful in getting. But let's, if I may, just paint a scenario for a person that the only thing on their record is an arrest for an assault and there's nothing else, and they have the ability to look into the future and know that they are never going to get any more offenses. Yes, I would say it's absolutely worth it, because that one thing on their record can be wiped off. Or if it's a person who every other offense is totally ineligible, but there is an arrest out there that is eligible, yeah, I would pursue it. as it relates to, especially to Missouri, but just nationally, expungement is not the end all. It's not the end all be all for taking steps to undo some of the impact that these criminal records face. But the focus on it now is really because it's a tool. It's a tool that we have. Improvements are being made to it at a snail's pace, but improvements are being made to it. So since it is a tool in our toolbox, that leads to the goal of bringing attention and awareness to it. We're all too familiar with the saying of a person finishing their sentence is them paying their debt to society, and yet criminal records just unfortunately just have a gross impact on people's lives, even beyond that debt to society being paid. Criminal records are just a grossly inflated debt to society. And so expungement is just one way to offer the state a second chance to correct the mistake that they're making and allowing these records to follow people as they are following them beyond the completion of their sentencing. So it would be great for our expungement laws specifically to continue to improve, because again, the state really needs this second chance to correct the harm that they are allowing their records of criminal offenses to have on people, well beyond the point of finishing their sentencing.
Okay, this is the last question. If you're arrested but never charged for a crime that is not expungible under 610140, can it be expunged because you were never convicted or pled to it?
I am.
I'm sorry. One more question after that. I just saw it. Sorry. But
okay, no worries. So as it relates to the law that we're focusing on, which is again Statute 610.140, if the offense that it relates to is ineligible, is ineligible, even if charges were never pressed, which is terrible, which is a point that needs to be changed in the law. But the direct answer is, under the law that we're focusing on, that offense, the record of that arrest, despite the fact that charges were never pressed or a conviction never followed, is still not eligible for expungement.
Okay, last question. I have a 30-year-old felony that I am in the process of having expunged. However, the court has recently asked for my fingerprints. How do you go about having that done?
Okay, great question. And this is another expense that's related to expungement. I'm going to round up to $30, but I think it's about $28.50, somewhere around there. So $30. You can have a fingerprint background check performed by the Missouri State Highway Patrol. And so those fingerprints can be collected at some of the individual locations established by the company. I believe it's Identigo, something like Identigo. But this information can be found on the Missouri State Highway Patrol website. But that's an option. That site would tell you can either go to one of those individual locations or a police department. You can pick the location of your choosing. I have had experience in going into the non-police department options in helping various clients, and it's a pretty quick process. They're my preferred locations. So a little bit more about that. That's just going to allow a person to get more information about their total record. And so that background check is really helpful because it is going to get some of those records that CaseNet and MuniCourt.net just won't show. For example, if a person has an SIS on their record, which is a suspended imposition of sentence, which means that a person was went through the court process, and they either enter the plea, or at the end of the trial, the judge just allowed them to have an SIS, which is going to give a period of probation. And once that period of probation is successfully completed, then their record is sealed. So it's going to have the same impact of an expunged record, meaning it's now sealed and is a confidential record. So those records can be revealed through the background check performed by the Missouri State Highway Patrol. But I will, absolutely, considering that it costs, I would really press trying to utilize some of those free options to get a picture of your background and make performing that background check the last step. And that's just generally because I believe the person posing the question said that they're already going through this process.
Okay.
Was that the last question?
That was the last question. Does anyone have anything else? There are a couple people in the chat who are thanking you so much for doing this presentation.
Oh, thank you. I appreciate y'all time so much. It's what's today? Wednesday? It's Wednesday evening, and you dedicated an hour and a half plus of your time to me. I really appreciate it. I am going to share my screen just one more time just to plug our contact information. I'm sorry, is my screen still visible?
Yes.
Oh, okay. So here's some of our contact information. And by our city, I would really encourage everyone to go to our website and join our mailing list so that you can get information about more of the events and programs that our city is working on, but to also stay up to date with more information that relates to our expungement work. And with that being said, Inez, I appreciate you as well, and Deaconess Foundation. Thank you all very much.
Thank you. Everyone have a great evening, and